In this educational breakdown, we are going to walk through a hypothetical federal legal scenario to understand how the United States justice system handles emergency Supreme Court appeals, proffer agreements, spousal privilege, and grand jury testimony, because these are legal tools that exist in real life and are often misunderstood by the public. Imagine a situation where, early on a Thursday morning, the Supreme Court of the United States issues a short order that reads simply, "Application denied," rejecting an emergency appeal in a high-profile federal case, and all 9 justices agree without a written opinion or dissent. When that happens, it does not necessarily mean the court endorses the lower court's reasoning in detail, but it does signal that the justices found no urgent constitutional violation requiring immediate intervention, especially in emergency posture cases, where the legal standard is extremely high and the applicant must prove both a strong likelihood of success on the merits and irreparable harm that cannot be fixed later. In our hypothetical scenario, the appeal concerns whether a spouse who voluntarily agreed to cooperate with federal prosecutors can be blocked from testifying before a grand jury by invoking spousal privilege. And to understand this, we first need to break down what spousal privilege actually is under U.S. law, because there are 2 distinct doctrines that people often confuse: the adverse spousal testimonial privilege and the marital communications privilege. The adverse testimonial privilege, clarified by the Supreme Court in Trammel v. United States in 1980, generally gives the witness spouse the right to decide whether or not to testify against their partner in criminal proceedings, meaning the privilege belongs to the witness, not the defendant, while the marital communications privilege protects confidential communications made during the marriage, and that protection can sometimes be asserted by either spouse. But even that privilege has limits and exceptions. In this hypothetical educational example, suppose the witness spouse voluntarily approaches federal prosecutors through counsel and enters into what is known as a proffer agreement, sometimes informally referred to as a queen for a day agreement, which allows the witness to preview what information they can provide without that statement itself being directly used against them in the government's case in chief if negotiations fail, although there are important exceptions, such as for impeachment or false statements. Proffer agreements are common in federal investigations and serve as a structured way for prosecutors to evaluate the credibility, usefulness, and scope of a witness's knowledge before offering any form of immunity or formal cooperation agreement. If the witness spouse indicates they are willing to provide financial documents, electronic communications, or testimony that may corroborate other witnesses, prosecutors would evaluate whether the cooperation is voluntary, whether the witness has independent criminal exposure, and what type of immunity, if any, might be appropriate. And it is important to note that immunity can take different forms, including transactional immunity, which is broad protection from prosecution for offenses related to the testimony, or use immunity, which prevents the government from using the witness's testimony or evidence derived directly from it against them, though it does not prevent prosecution based on independent evidence. Now imagine that the defendant's legal team responds quickly by filing an emergency application to the Supreme Court seeking to block the spouse's testimony, arguing that allowing it would violate marital privacy or constitutional protections. Emergency applications to the Supreme Court are extraordinary remedies, not routine appeals, and they are often resolved through brief orders without full briefing or oral argument, especially when the court determines that existing precedent clearly governs the issue. If the justices deny the application without comment and without issuing a stay, that typically means the lower court's ruling stands and the legal process continues. And in practical terms, if the matter involves a federal grand jury, the witness could be scheduled to testify according to the grand jury's regular session calendar. Grand juries, which operate in secrecy, are investigative bodies that determine whether there is probable cause to bring criminal charges, and they do not decide guilt or innocence. Instead, they hear evidence presented by prosecutors, including documents, recordings, and witness testimony, and they can return an indictment if probable cause exists. In white-collar cases involving allegations such as bank fraud, tax fraud, or falsification of business records, documentation is often central, including tax filings signed under penalty of perjury, loan applications, financial statements, and internal communications. And when multiple witnesses corroborate one another, prosecutors may view that as strengthening the reliability of the evidence. However, the defense retains the right to challenge admissibility, credibility, and the sufficiency of evidence through pre-trial motions and at trial. In our educational scenario, if the spouse signed joint tax returns, the legal implications would depend on knowledge and intent, because criminal liability in fraud cases typically requires proof that the defendant knowingly and willfully participated in a scheme to defraud, not merely that they were associated with someone accused of wrongdoing. And this distinction is critical in U.S. criminal law, where intent often separates criminal conduct from civil liability or innocent error. If prosecutors believe new evidence supports additional charges beyond those already filed, they may seek a superseding indictment, which replaces or expands upon an earlier indictment and can add counts or defendants. But such decisions depend on evidentiary sufficiency and prosecutorial discretion, and defendants maintain the presumption of innocence throughout the process. Regarding conspiracy charges, federal law generally requires proof of an agreement between two or more persons to commit an unlawful act and at least one overt act in furtherance of that agreement, and courts evaluate evidence carefully to determine whether statements or actions demonstrate a knowing agreement rather than mere parallel conduct or misunderstanding. When the Supreme Court declines to intervene in an emergency context, it often reflects the principle that not every dispute warrants immediate constitutional review, particularly when established precedent, such as the allocation of testimonial privilege to the witness spouse, already provides clear guidance. The court's silence in such cases should not automatically be interpreted as endorsement of factual allegations, but rather as a procedural decision that the applicant has not met the demanding standard required for extraordinary relief. From a broader educational standpoint, this hypothetical illustrates several structural features of the U.S. legal system. First, privileges can be waived voluntarily. Second, emergency appeals are limited tools with strict standards. Third, grand jury proceedings are investigative rather than adjudicative. Fourth, immunity agreements are negotiated instruments designed to balance truth-seeking with fairness. And fifth, constitutional protections coexist with prosecutorial authority in a system built on adversarial testing of evidence. It also demonstrates how timing in legal proceedings can appear dramatic to observers, even though courts and prosecutors often operate according to procedural schedules rather than coordinated narratives, and how media coverage sometimes compresses complex procedural steps into simplified storylines. Ultimately, in any real-world case, guilt or innocence would be determined by a jury after full presentation of admissible evidence, cross-examination, judicial rulings on motions, and application of the beyond a reasonable doubt standard, and no Supreme Court order denying emergency relief eliminates a defendant's constitutional rights at trial. Instead, it simply allows the ordinary judicial process to continue. For students of law, the key takeaway from this hypothetical scenario is that spousal privilege, proffer agreements, emergency Supreme Court applications, and grand jury testimony are governed by long-standing doctrines and procedural safeguards designed to maintain fairness while allowing investigations to proceed. And understanding those doctrines requires careful attention to precedent, statutory authority, and constitutional limits rather than assumptions based on headlines or political context.